continue with witness Fiesel. Mr. Finley, if you'd like to take up where you left off.
Thank you. Ms. Fiesel, one of the things that we talked about yesterday had to do with the frequency of rate cases for Water Resources, Inc., right?
Correct.
And you did hear the company witness Abbott testified that but for the construction of the interconnection with the town of Harrisburg and the time it took to do that, he would have come in more sooner than he did. You heard him testify that, did you?
I heard about that.
Right.
Yes.
Now, when was the last time, if you know, that Water Resources Incorporated was earning its authorized rate of return?
Let me go back to my note and take a look at it. The last time Water Resources come in for rate case is 2018. The final order is approved on November 21st, 2018.
Well, that's an answer anyway. You would agree with me, would you not, that in a time for relative high inflation and when there is not much growth in customers within the subdivision served by a small water or sewer utility, as time goes by, often the company is unable to earn its authorized rate of return. Would you agree with that?
I'm not disagree with that because the company has the option to file rate case when they are ready and choose to file rate case.
Okay, but absent the filing of a rate case, when there is lack of growth and high inflation, it is difficult between the rate cases, no matter the frequency of them, to earn the authorized rate of return. Would you agree with that or not?
Just repeat the question, please, again.
All right, irrespective of the frequency between general rate cases, when there is high inflation and lack of growth in revenues within the subdivision, it is difficult for a small water or sewer utility to earn its authorized rate of return. Would you agree with that or not?
If the company does not come in for rate case to recover the expenses due to high inflation, then the company is not able to recover, but it's the company's duty to come in for rate case to recover the expenses that actually incurred due to inflation and other factors.
So if, as we go forward, we are in a period of high inflation and no customer growth, then it would be incumbent upon the company, to the extent it is not earning its rate of return, to come in more quickly than 5 years.
Could you repeat? I mean,
No,
I believe
no, I won't repeat that. Never mind. Answer yourself. I asked you yesterday about recovery of rate case expenses having to do with this company and what you said in your testimony to justify your recommendation. And you gave a long answer where you cited authority that was not in your testimony of 2 electric rate cases. Did you not?
I gave the 2 electric rate cases as an example yesterday.
All right. And one of them was Duke Energy Progress rate case, E2 sub 1300, right?
Correct.
All right. Let me, in spite of the fact that we didn't have that before yesterday, we looked over the night to try to find that case. And I'm looking at page 205 of the order that you cited yesterday. Let me just read you a few sentences of it. The commission determines that in the ordinary course of rate making, the rate case expense amount to be recovered from customers should be established in the current general rate case proceeding and not reevaluated in the future rate case for recovery from customers. Generally, it has been past practice of the public staff and the utility to work together to estimate an appropriate amount of rate case expense for approval of the commission to reflect the activity occurring after the agreed upon update cutoff date to the conclusion of the hearing and through the preparation of proposed orders. You remember that part of the order that you cited yesterday? Page 205.
Which paragraph? I only have paragraph 45 in my notes. I don't, what you read is not showing in my notes.
You want to look at it?
Yes, I have finished reviewing.
Well, good. Now, let me ask you a question about a rate case expense for a large company like Duke Energy Carolinas and Duke Energy Progress. When those companies come in for a general rate case, they spend millions of dollars in rate case expense, do they not?
They do tend to have large rate case expenses.
And with respect to the total cost of service, the total revenue requirement, would you agree with me that the percentage of that that is rate case expense is much lower than the total rate case expense for a small water and sewer company like Water Resources Incorporated in this case?
That really depends on how much revenue and how much rate case expenses are. So without the number here, I cannot give you an answer of yes or no.
All right. Fair enough. tell me whether or not the public staff recommends in this case that the company be allowed to recover its costs of rate case expense through the preparation of the proposed order as is addressed in this DEP rate case.
I did not do the DP rate case, so I don't know whether it's through the proposed order or through the expert hearing. But this, what you have me here, is from a settlement talk, which is not presidential.
Thank you. So the cases that you cited to us yesterday in opposition to this case where the rate case expense is contested were based on a settlement. Is that what just your last answer, was it not?
The regulatory liability, or in other words, the methodology we recommend for WRI is not contested item. The company willingly filed in their application that they will return the over collection of rate case expenses to customers. So this is not new. This is not contested.
Let me ask you the question again, and Ms. Beasley, if you just please listen to the question and answer the question, we'd be through here a lot more quickly. In this case, is the public staff recommending that the company be allowed to recover through rate case expense, in this case, what they incur through the preparation of the proposed order, or are you asking that the rate case expenses be cut off more quickly than that?
By this case, do you mean WRI or DEP?
This case, I'm asking about this case.
WRI. In the WRI case, we recommend to update the rate case expense through the close of expert hearing.
But not through the preparation of proposed orders and other post rate case hearing expenses, right?
Correct, because we need to audit expenses, audit invoices to include only prudently incurred cost into our schedule to calculate revenue requirement. Because we don't have any invoices post-expert hearing, we are not able to include any actual expenses post-expert hearing. But we do include our estimated mailing cost and postage expenses for the customer notice in our schedules because we are able to estimate that. But we are not able to estimate how many hours the company will work after post-hearing through the proposed order.
Well, you certainly can't look at invoices for work done after the close of the hearing today before the hearing ends, can you?
Well, the company do not provide any invoices after hearing, so I cannot include anything after hearing. Also, under General Statute 62-133, regarding how the rates is fixed, it's regulated that the test year include 12 months historical operating experience prior to the day the rates are proposed to become effective. But the Commission shall consider such relevant material and competent evidence as may be offered by any party to the proceeding tending to show actual changes in costs, revenues, or the cost of the public utilities property used and useful, or to be used and useful within a reasonable time after the test period in providing the service rendered to the public within the state, including construction work in progress, which is based upon circumstances and events occurring up to the time the hearing is closed. So my recommendation is based on the schedule. The updates based on updates through the date hearing is closed, not through the proposed order is closed.
All right, so it's your opinion that to the extent in the past, including this DEP rate case that you cited yesterday, the Commission has allowed the company to recover rate case expense, including proposed orders, that violates 62-133. Is that your testimony then?
If you're talking about DEP is not written. The testimony is not written by me, but this is the settlement. So if we, in DEP case, if we did include rate case after hearing through proposed order, that is a settlement,
All right.
which is not precedent.
Well, the commission is not going to approve a settlement that is unlawful, is it?
I don't hear anything about proving settlement is unlawful.
Well, if this was a settled case, those settlements stipulations usually include a statement at the bottom that if the commission does not approve this settlement in totality, it is null and void and can't be enforced. Do they not?
If you mean, if this is the settlement case,
Talking about the type of settlement, you said this was a settled case that you cited yesterday, E2 sub 1300, and you said it was a settled case. And I'm asking you that when the commission approves a settlement in a case like this, if the settlement doesn't usually have the phrase at the bottom, unless all these provisions are included in their entirety, the settlement is null and void.
I'm gonna object to that. It calls for a legal conclusion.
Madam Peer examiner, the lady has just quoted the statute and told you that that's the basis of her answer. Come on now.
I think the case speaks for itself.
I'm going to overrule and have the witness just answer based on the best of.
your question is, yeah, just to repeat, your question is just too long.
It says in this order that you quoted yesterday on page 205 that the recovery is for preparation of the proposed orders, which is after the end of the hearing. And are you telling me that because that is in this order that what the commission did violates 62-133?
I did not say that.
But I didn't ask you if you said it or not. I asked you to give me an
No,
answer.
your question is, did I say the court has violated? I
didn't hear your answer. Sorry.
Okay, just repeat your question. You said
We'll
based on this-
move on. Ms. Friesen, I don't think. Let me ask you about this concept of regulatory liability, if you don't mind. I'm correct, am I not, in my understanding that with respect to the rate case expense, the public staff is in effect asking for the creation of a regulatory asset/liability for rate case expenses to be set aside in a special regulatory account to be addressed outside of the recovery of the other cost of service elements.
No. Regulatory, we do not ask the company to set a regular asset account. And the regular liability account is under the uniform system of accounts. Under 253, it specifically gives the definition of regular liability account is. So the company can have that account and does not default accounting to do that.
All right, well, let me rephrase the question just a little bit differently. With respect to the rate case expenses, the public staff in effect is asking for the creation of a regulatory liability for rate case expenses to be set aside in a special regulatory account to be addressed outside of the recovery of the other cost of service elements.
Yes, to record the overcollection of rate case expenses.
And your recommendation is in effect that those costs be what I'll say trued up over time in future rate cases. Will you accept that?
I believe I do not use the word of true up. Can you direct me to the?
No, you didn't. You
pages?
didn't use that term. If you disagree with the question, just say you disagree.
Can you redirect me to the pages where I wrote that? Let me review it again.
The pages are pages 14, beginning at line 10 through page 15, line 9, which we read into the record yesterday. And I'm asking you about the mechanism that you asked the commission to approve for rate case expenses. And I'm not trying to trick you. I'm just trying to understand what you're asking for so we can talk about it.
So let's just say page 14, starting from which line?
10. And I just use a shorthand recitation of what I understand you to be recommending. I'm not trying to trick you at this point.
So
Why don't you
So
describe
question-
why don't you describe the mechanism that you're recommending so we won't quibble over words?
the mechanism I'm recommending is if the company comes in for a rate case after it fully recovers the rate case expenses approved in this current case, then the company over collect money from the repairs. Therefore, the company needs to put the over collection of the money, rate case expenses, starting from the first month after the company fully recovered its rate case expenses in a regulatory liability account on a monthly basis. And this, the company will continue to record the over collection of rate case expenses in this regulatory liability account until the final order of the next rate case issued. Because from the date the company started over collection through the final order date issued for the next rate case, the company continues to collect rate case expenses from repairs for expenses the company does not incur anymore. That is over collection. We recommend the company to record this amount in the regulatory liability account to be determined the amount to be refunded to customers in the next rate case, along with interest calculated based on weighted average cost of capital.
In that answer, you used 3 times the word regulatory liability account, did you not? And my question to you is, that's one of the things that you're asking the commission to do, is to establish a regulatory liability account. I'm not trying to trick you. I'm just saying that's what you're asking. In order to do those things that you said in the future, you've got to, let me finish. You've got to establish the regulatory liability account in this case. Isn't that right?
Yes, if the company does not already have one, then yes.
All right. And that is in a different situation from other expenses like maintenance expenses and general cases, general expenses that don't go into a regulatory liability account, right?
Different circumstances, I mean, those are different accounts.
Yes,
So
general rate case accounts, not regulatory liability accounts, right? Nothing, I'm not trying to trick you. I'm just trying
those
to
are
give you the
different types
distinction.
of accounts.
Right, okay. Ms. Feasel, the rate case expense that the company is incurring today and has been incurring up to now and will be incurring through the preparation of proposed orders is being financed by the equity investor of the company. Would you agree with that?
Is being financed by the investor, which investor?
I'm sorry.
Which investor you said? You said it's being financed.
The only
Because I'm
investor.
not,
Yeah, okay, but the investor.
I'm not the econ team, so I don't know which investor. This question should have been addressed by an expert in the econ team.
So you don't know the answer to that question then?
I don't know who financed the company.
Well, hypothetically, Ms. Feasel, if the cost of this case is being financed by the investor in Water Resources Corporation, the longer it takes for it to recover those costs, the longer the investor goes without its investment, unless the commission allows a return on that unamortized portion. Would you agree with that? Hypothetically.
Hypothetically, if there is well, let me make a correction here. When you just say unamortized portion,
Yeah.
that is not correct statement because rate case expense is not ongoing expenses. We normalize that. So if there is any remaining, that is not an amortized balance,
All right,
which means it does not get a return on the rate base.
let's call it a normalized expense, but the longer the time goes by, that the investor gets that normalized money back the longer he goes without a return on it, right?
The longer the rate case goes by, the longer time you said the investor
Yes.
will do what?
The longer the investor goes without recovery of his money.
No, I disagree.
Right. Let me, let's talk a little bit then about, regulatory liability account, if we might. And I'm going to ask you, about a paragraph out of a DEC rate case. And the only thing I'm going to ask you about this for is so we can set in front of us a definition in that case about what I think you're talking about when you say regulatory liability account. Okay? So just please listen to me. It's a docket number E7 sub 1146, order dated June 22, 2018. And I'm reading the evidence and conclusions for finding of fact number 79, pages 27 and pages, also pages 326 and 327. But this is just a definition. I want to see if you agree with what I read into the record here. The commission agrees with DEC's recommended approach, comma, not only for CCR costs, but also for all costs for all accounts. A deferred cost is not the same as the cost of service expenses recovered in the company's non-fuel based rates. A deferred cost is an exception to the general principle that the company's current cost of service expenses should be recovered as part of the company's current revenues. When the commission approves a typical cost of service, such as salaries and depreciation expense, there is a reasonable expectation that the expense will continue at essentially the same level until the company's next general rate case, at which time it will be reset. On the other hand, when the commission approves a deferred cost, the commission identifies the specific amount that has already been incurred by the company, or in the case of CCR cost, is estimated to be incurred by the company. In addition, the commission sets the recovery of the amount over a specific period of time. Further, the company is directed to record the recovery of the specific amount in a regulatory asset account rather than a general revenue account. If the company continues to recover the deferred cost for a longer period of time than the amortization period approved by the commission, that does not mean that DEC is then entitled to convert those deferred costs into general revenues and recording them in their general revenue accounts. Rather, the company should continue to record all amounts recovered as deferred costs in a specific regulatory asset account established for those deferred costs until the company's next general rate case. Now, this deals with a regulatory asset account, but the principle would apply to a regulatory liability account, would it not?
I disagree.
Okay.
In this WRI case,
You disagree with what I just said?
correct.
Now, are you familiar with that case? That's the case where the DEC and DEP were trying to recover their cost of coal ash remediation. You're familiar with those cases?
I did not do the DEP-DEC, especially regarding the coal ashes cases. I just know that for the DEC and the DEP cases, the company filed with the commission in their application to refund the over collection of rate case expenses to customers, which is not a contested issue. But if you ask me about any other issues regarding CPRE, then I don't know.
Right. Do you know whether or not if you don't know what I just read, anything more about the case, you don't know whether or not when the commission approved the deferral of those costs, it allowed a return on them?
I
You
did
don't know the answer to that.
I did not know,
Okay.
but in the WRI case, we did not say anything about deferred accounting.
It's amortization. You call it amortization.
Refund, it's called.
In the company's rebuttal, the company said deferred accounting. But in our recommendation, I recommend to put the overcollection to regular liability, which we do not need a deferred accounting to do that.
Are you advocating that the company earn a return on what is put in the regulatory liability account? Or not?
If the company over collect money from repairs, then yes, essentially, the company does not only over collect the money for the amortization expenses, but it also earn a return for the amortization expenses, which is why we recommend the company to return not only the over collection, but also with the interest.
Well, what I'm asking you about is the establishment of the account, regulatory liability account in this case, not what happens in a future rate case. And my question to you is, are you or are you not recommending to the commission that on those funds, while they are accruing, while they are in that account, are you recommending that the company earn a return or not?
Yes. Let me just clarify that.
All right.
Yes, I mean, when the company over collect, they put the money under the regulatory liability account, that is a cost-free capital for the company to use, which the company earn and return it should not have earned.
Let's see. Can I just have a few minutes? A few minutes. So-
Yes, we're going to take just a 5-minute break. Is that what you need, Mr. Finley? We're going to go off the record for just a few minutes.
Ms. Fiedel, would you agree with me that when commission sets up a regulatory liability account, it has to do that through its order and recognize it as such?
I do not believe that we have to have an order to help the company to set a regulatory liability account.
So it's your opinion that in order to set up a regulatory liability account, it does not require the commission's approval?
That's correct.
Do you have any authority to back that up?
Under the Uniform System of Accounts, under the 253, we have the definition of the regulatory liabilities. These accounts shall include amounts of regulatory liabilities not included in other accounts imposed on the utility by the rate-making actions of regulatory agencies. The amounts to be included in this account are to be established by those credits which would have been included in net income determinations in the current period under the general requirements of the Uniform System of Accounts, but for it being probable that, 1, such items will be included in the different periods for purpose of developing rates that the utility is authorized to charge its utility services, or 2, refunds to customers not provided for in other accounts will be required. Therefore, it's definitely defined in the Uniform System of Accounts under 253.1 that regulatory liability account is used to record the refund to customers. So it does not require commission order for the company to build this account.
So you don't care whether the commission in this case issues an order addressing and approving the regulatory liability account that you recommend in this case?
Can I repeat? Did you, in the beginning of your sentence, did you say I don't care?
Okay. Do you care whether or not the commission in this case approves your recommendation to set up a regulatory liability account in its order in this case?
I believe it's not up to my careness or not, but it's a fact that regulatory liability account is under the utilities Uniform System of Accounts. It's a fact. The company does need a commission order, or we do not need to file a petition for the commission order to authorize the company to set up this account.
That's your opinion. You are aware, are you not, that in past cases, the commission has approved regulatory liability accounts and regulatory asset accounts in its orders?
Yes,
And it's not the test there, Ms. Fiesel, in order to do that, rather than recover those costs, is regular cost of service accounts, that the cost is unusual, unexpected, and material. Isn't that one of the tests that the commission employs?
what we are talking about is deferred accounting, but we were talking about regulatory liability, so there are different concepts.
So this is not a deferral you're asking for.
Correct, this is not deferral.
And it's not the second test that it has the regulatory asset or liability has a material impact on earnings when the commission sets up a deferral based on the creation of a regulatory asset or liability account.
Well, I will repeat again, this is not deferral accounting, so we do not need a deferral accounting to set regulatory liability account.
Okay. But if the commission were to disagree with you that it is a deferral, despite what you say, would you agree with me that the test is that it's got to be material and unexpected, and that it has a meaningful material effect on earnings?
Those are the tests for deferral accounting, but again, this case is not related to the deferral accounting.
All right. Are you familiar with, well, I'll just give you a little preview that our witnesses disagree with you on that. Are you familiar with the concept of the two prongs of the test to create a deferred account in some cases?
Can you defer me to the pages of the company's rebuttal? Just let me read the two tests.
No, I'm not asking you about that right now. I'm asking you just Based on your general knowledge and accounting experience, are you familiar with what is referred to in this commission as the two-prong test? If you don't know anything about that, just let me know.
I heard about these two-prong tests for different accounting.
Okay? Or does what I've said about it a moment ago, is that in accord or not in accord with what you know about it? The two-prong test.
In accord or not in accord?
Beg pardon?
Sorry, could you repeat the question?
No, ma'am, I'm not going to repeat it. Let me read you another, that page I gave you out of the DEP order, the sub 1300. Let me read you another paragraph below the one that I just read to you a minute ago. It says, concerning DEP's adjustment to include the unamortized portion of rate case expense in rate base, the commission gives significant weight to the public staff's testimony that the amortization of rate case expense should reflect a normalization of the cost associated with the filing of the rate case based on an average of the number of years between the rate case filing. The commission notes that in the 2019 first partial settlement expressly provided that the unamortized balance of the rate case expense would not be included in rate base. The commission concludes that DEP's request to include the amortized balance of the rate case expense in rate base is denied. Have I read that
Yes, you read it.
correctly? All right. Now, the company submitted the public staff a data request asking for the authorities that the public staff relies upon in the recommendation that you make here on pages 14 and 15 of your pre-file testimony, correct? And the first sentence that I want to read to you is the public staff did not conduct an exhaustive research of the docket system, which was available to the company to find all dockets involving regulatory liability accounts. And then you cite the Aqua case, W-218 sub 73, right?
Correct.
So are you basically saying there that you basically said that the company can find that information itself as opposed to a search of the docket system?
Correct.
And this came up yesterday. So is it your view that it's the company's position to refute the recommendations that you make? Not your responsibility to support them with the authorities.
It's the company's responsibility to support its case. That's your question?
Is it the company's response? Does the company have the burden of proof to point out where your recommendations are invalid, or do you have to support them yourself?
I believe I gave example to support myself already in our response.
In your testimony or the response that you've given to the staff?
The response to DR request.
See here. So let's talk about the mechanism that you have. You've discussed this in your testimony, you discussed it today. So this is tracked. The rate case expenses are tracked going into the future. Would you agree with the word tracked?
You mean tracked the over collection?
Well, it tracked what? Yeah, okay. Let's do over collection. Track over collection.
Yes, yeah, it's a tracking.
Over collections. And to the extent there's an over collection based on examination of the account at the end of 5 years, it is your recommendation that if there's a general rate case at the end of the 5 years, that what is overcollected in the account be refunded to customers with interest,
Correct.
right? But it's not really interest, is it? It's the full authorized return. It's not an interest return, it's the full authorized return. That's how you calculate it.
Those two words are interchangeable. It's the over collection themselves plus the interest, or if you say return.
Okay. Right. Now, so if in that next case, if it comes 5 years from now, but the third case is 10 years from now, then there's going to be a long period of time in there when that amortization or whatever you want to call it occurs, right?
Why there is a third case? You mean you mean this case is the first case, and the next is second, and then company filed the third rate case in 10 years?
No. Yeah, so then, but there's a long period of time when this return of the overcollection, as you call it, with interest is taking place.
That depends on when the company comes in for rate case.
Sure. But so we're asking in your recommendation here that some customers way off into the future be responsible for, to get credit for overcollection of rate case expenses incurred today. Not the customers that are on the system today, right?
You're talking about the over collection, but if the company over collect, regardless of the size of the company, they need to return the over collection to the customers in the manner that determined by the commission.
All right. Now, if, and you also addressed this in your testimony, if there is an under collection, it's got to be, I use the word tracked, and I think you allow me to use the word tracked, right?
It's okay.
If it is tracked and there is an under collection, then you don't recommend that the company earn a return on the under collection, and you leave it up to the commission. You don't address exactly the mechanism that you recommend the commission to follow in addressing the under collection. Am I correct about that?
I disagree with that statement
What is wrong with it?
because the remaining balance of the current rate case that you have not got an opportunity to recover before you file the next rate case is added in the rate case expenses in the next rate case, which the total rate cases then amortized over certain years approved by the commission is one of the factor in cash working capital, which the company earn a return. Therefore, the company still earn a return on the remaining balance of the current rate case.
See. Let me talk to you, Ms. Feasel, about salary expense. Okay?
Yeah.
With respect to salary expense, customary method of establishing test year salary expenses to look at the level of expense at the end of the test period or at a level of salary expense to be incurred at the time of the hearing and the case concludes, unless for some reason the level of the salary expense is unrepresentative. Would you agree with that?
Yes.
You would?
Yes.
Right. And the company has indicated that with respect to its employee, Beth Lockwood, she has been given increase in the salary that she is to receive beginning May 9, 2024. Would you agree with that?
The salary beginning effective May 9th is already beyond the test period and also beyond the updated test period in this case, so it will not apply to the case.
All right, I think you just read a minute ago the definition of what's in the statute, 62-133. And it talks about a reasonable period of time after the test year up until the close of the hearing, does it not? Want to look at it again?
It does say that, yes, but in the scheduling order, the commission said the company has up through March 12th to provide updates to revenues, expenses, and other rate-based items. The company has not been able to provide any supporting document to salaries regarding the rate or hours, nor did the company give us any updates for the salaries as you indicated, effective May the 9th. If we will update salary for May, effective through May, we will have to update all the other expenses. We will also have to update accumulated depreciation through the associated time period for the matching purpose.
Well, you mentioned the commission's order establishing the case, and then you read 62-133. Do you think the commission's establishing order overrides the statute?
That I don't know. This is a legal question.
May I pass out an exhibit, Madam Hearing Officer?
Yes.
We have this marked, Madam Hearing Officer, as WRI Faisal Cross-Examination Exhibit number 1, please.
Okay, so WRI, can I say feasible cross-examine
number
exhibit 1? Okay, it will be so marked.
Would you accept, Ms. Faisal, that that is an indication of the salary of Ms. Lockwood as of May 9, 2024?
You mean the 15,000 as of May 9, 2024? I cannot accept that. Oh, can I have a copy of that? I didn't see.
You didn't get, did I not give you a copy?
No.
Did you see that now?
Yes,
Did the public staff not receive a copy of that last week?
yes.
Now, let me ask you about professional expenses. I think you addressed that on page 13, line 8.
Line 8.
And I'm going to read a sentence out of the rebuttal testimony and ask you to comment on it. In the rebuttal testimony on page 24, line 17, rebuttal witness.
Just give me a second. Let me get to that page.
Sure.
Mr. Finley, would you repeat that page number, please?
I think it's the Faisal
Excuse me, the rebuttal.
of the rebuttal is on page 24. I think it's line 17.
Thank you.
Okay, I'm on the rebuttal page.
Okay. Rebuttal witnesses maintain that witness Faisal has only left in amounts for the tax return preparation and preparation for the annual report. Basically, there are no ongoing levels of professional expense for customer complaints, bond filings, or other professional fees associated with compliance with any commission mandate. While removing all of these fees, the public staff has stripped the company of its opportunity to defend itself against any customer complaint or issues that may arise outside of the company's control. And this is completely unfair. What is your response to that?
The reason as to why these are removed are not covered in my testimony. This is a question best be answered by witness Hauser.
All right. You made the adjustment, but I should have asked Mr. Hauser, is that what you're doing?
I did not make, my schedule reflects the adjustment of Mr. Hauser, but he recommends the adjustment. I only reflect the numbers.
Okay. Do you maintain that these are the only expenses that you've allowed here that the company is likely to incur as professional expenses while these rates are in effect?
Well, again, these are Hauser adjustments. So I think this question should be answered by Mr. Hauser.
Well, I appreciate that, but it's a sort of a simple question. Or do you have no opinion on it then?
Do you mind if you repeat your question? Because in my testimony, I have addressed this, what I have removed.
Well, is it your opinion that only the fees that you have recommended as professional expenses on a go-forward basis are those and only those that the company is likely to experience while these rates are in effect? And if you have no opinion on that, just say I have no opinion.
Well, I have to repeat my answer again. Those are the adjustments by Mrs. Hauser. By Mr. Hauser, I only reflect the numbers in my schedule.
All right, thank you, Ms. Fiesel.
Mr. Finley, does that complete your cross of Ms. Fiesel?
Yes, ma'am.
Okay, redirect.
Okay, thank you. All right, let's see. First, Ms. Fiesel, Mr. Finley passed out, an excerpt from the DEP sub 1300 rate case.
Hmm.
And pertaining to rate case expense, agreed upon rate case expense.
Correct.
And in pertaining to the first highlighted period, I'm sorry, the first highlighted sentence. Could you read that
Yes.
complete sentence?
Generally, it has been past practice for the public staff and the utility to work together to estimate an appropriate amount of rate case expense for approval by the commission to reflect the activities occurring after the agreed upon update cutoff date to the conclusion of the hearing or through the preparation of proposed orders.
So this conclusion of the commission says, or
Correct.
the cutoff date through the conclusion of the hearing or through the preparation of proposed order,
That's correct.
either or.
Either or, depends on which one is reasonable, the commission has decision to make.
Okay, thank you.
Mhm.
Now, with regard to staying on the same DEP case. I'm going to hand out an excerpt of our testimony in the DEP case. Ms. Feasel, I direct everyone's attention to page 31.
Mhm.
On page 31, lines 13 through 19,
Mhm.
in the joint testimony of Zhang and Boswell,
Mhm.
and the joint witnesses are discussing the adjustment of the unamortized balance in rate base. And they discuss a normalization of the cost,
Mm.
correct?
Correct.
Okay. And based on the number of years. And it also states that these costs would have to be extraordinary in nature in order to receive rate-based treatment.
That's
Correct.
correct.
So that would not be applicable in the case, the proceeding today, would it?
It would not, because the remaining balance would not be, would not have a rebate treatment.
Okay, thank you. And this was, this treatment by the public staff was agreed upon. I mean, it was approved by the commission.
That's correct.
Okay, thank you. All right. Now, Mr. Finley had several questions regarding deferral accounting. Is the public staff proposing a deferral in
No.
this case?
We did not.
Can a regulatory liability, do you have to have a deferral in order to set up a regulatory liability account?
No, we do not need a deferral accounting to set up regular liability.
And that's based on,
That is based on the uniform system of count under 253.1.
okay. Sorry, I'm checking my notes. Now, just to clarify, Ms. Feasel, Mr. Finley asked you if the public staff recommendation regarding the company establishing a regulatory liability for recovery, for refunding
Refund.
the overcollection to customers
Mhm.
needed to be approved by the commission. Now, to clarify, the proposal should be approved by the commission, correct?
Our recommendation.
Our
should be-
recommendation.
Yes, should be
But-
approved, but we do not need the approval from the commission to set up the regulatory liability account.
Thank you. Sorry. Would a deferral be for costs that would otherwise be recovered from present rates if not for the deferral?
Could you repeat your question?
Would you have a deferral be for costs that would otherwise be, not be recoverable?
You mean rate case expenses? Yeah, that is not ongoing level expenses. So we normalize to help the company to recover this expense that the company would otherwise not be able to recover.
Okay, thank you. It's ongoing.
It's
I mean,
after
it's
we-
not
It's
an
not
ongoing,
ongoing, but we normalize that.
you normalize it.
Yes.
So that the,
So the company can recover the normalized amount.
would the company be allowed to continue to collect rate case expenses going forward if they come in early?
Yes, they are allowed to. It's also stated in my testimony.
If the company comes in before the end of the rate case amortization period, would the company collect only the balance of the cost experience?
No, if they have any remaining balance when they come before the end of the amortization period, the remaining balance will be added to the new rate case expenses in the next rate case. And together with the new rate case expenses, they will earn a return on cash working capital, which one of the components is rate case expenses. So they will earn a return.
They will continue to
They will continue
recover.
to recover the remaining balance and the return associated with the remaining balance.
Right. Now, Ms. Feasel, did you state correctly that there's a return on rate case expense?
Well, let me put it this way. Rate case expense is normalized expense, which is under the income statement items. It's when we calculate the cash working capital, rate case expense is one of the factors. And when the company earn a return on the rate base, they earn a return on the rate base, which one of that is cash working capital.
Okay.
But if the company over collect money from the ratepayers, they need to refund not only the over collection itself, but also the interest along with the over collection to prevent the company from double dipping the return the company collected based on the cash working capital.
Okay. But there is no return.
Correct, you are correct.
On
There
rate
is no
case
return.
expense.
Correct,
The company just receives the actual amount of the amortization.
correct.
Okay. Is the company harmed in any way by setting up a regulatory liability account?
Absolutely not. Because this regulatory liability account is used to track any over collection the company has collected from ratepayers after they fully collected the rate case expenses. If they do, they need to keep track of those over collections in this account so that in the next rate case, the company will know how much total over collection the company has so that the company can refund the customers of all the over collections.
Thank you. Ms. Feasel, you received the updated salary last week, correct?
I received the company's printed copy showing 15,000 effective May 9th.
Okay. When did you file your testimony?
April 12th. April 12th is the original direct testimony, and then I filed supplemental on April 26th.
Okay. Now, if you were to include the amount for this 2024 updated salary, would you need to update all the revenues and expenses?
Yes, I will have to update all of the expenses. I will also have to update the accumulated depreciation associated with the plant to meet the matching principle.
Okay,
And it will take us a long time to do that.
okay. So would the public staff have to engage in additional work?
That's correct. 3 to
About-
6 months at least.
And about how long would this take to complete?
About 3 to 6 months.
Okay, thank you. Sorry. Ms. Feasel, going back, I think, to yesterday, Mr. Finley asked you how the public staff determines the appropriate amortization period for a utility. Is it based on the size of the company?
No, it has nothing to do with the size. We normally analyze the amortization period based on the company's historical frequency of how frequent they file rate cases. And based on my analysis, the company filed the historical tendency of the company old rate cases normally from 4 to 9 years. Therefore, we believe 5 years is a conservative, reasonable estimate to use in this current case. And as I listed yesterday, there are different rate cases. Also have the final order approved and years gap.
I'm sorry.
As I stated yesterday, there are multiple rate cases, historical tendency rate cases. I have listed each rate case docket number and the date of the final approval. Therefore, we have the years gap between each case to prove that the frequency of the company filed rate cases are from 4 to 9 years.
Okay, thank you. One moment, we covered a lot of ground. Let me check my notes. All right. Thank you. I have no further questions.
Okay, thank you. Ms. Fiesel, I have just a couple of questions to clarify. Going back to this WRI Fiesel cross-examination Exhibit 1 that was passed out to you a few minutes ago and that Ms. Holt just asked you questions on. Regarding that May 9th, 2024 salary amount, that annual amount, did the company also provide you how many hours that represents and the hourly rate?
No, the company never provided any supporting documentation for the hourly rate or hours work.
Okay, so that this is all you have is
That's
the,
all I
okay.
have
All
for
right.
the May 9th.
Okay, I'm gonna follow up with the company on that question then. That's just a heads up. Mr. Finley, just, excuse me just one moment. Did we enter this into evidence? I just want to make sure for an abundance of caution.
Not yet.
All right.
Been marked.
You're gonna, it's been marked. Okay, all right. So we're gonna do that at the appropriate time then. Okay. Ms. Fiesel, also, regarding professional fees disallowed, I believe Mr. Hauser, referred me to you yesterday when I asked a question, on your schedule 3-4. And it's gonna be line 3, where you removed non-recoverable professional fees, based on the supporting documentation. And the amount of the public staff's adjustment, is $10,399.
Correct.
You're there? Okay. So, do you have the I'm sorry.
Excuse me. Are you talking about the direct testimony or direct schedule or the supplemental schedule?
I'm actually on the direct.
Direct.
It may be the same for the supplemental, but I'm on the direct.
Okay, schedule 3-4.
Yes.
The
mhm.
total adjustment we have is $10,665.
Yes, that's the total adjustment. And I am, so I'm wondering on, line 3, see, line 3, it's line 3, no, not recalculation, it's the adjustment to remove non-recoverable professional expense. I don't think it has a line number by it, but there it is, line 4 with documentation, with the word documentation. And it says $10,399. Do you see that?
Yes,
Okay, so that, as I'm understanding it, is where the public staff has removed professional fees related to matters such as bonding, complaint proceedings, perhaps items outside of the test period. Do you have any breakdown of what that is, what
Yes.
those amounts are?
Yes.
And could you provide that for the
yeah,
record?
we have copies.
Okay, so you're going to provide that?
Yes, we can provide that.
Okay, all right, okay,
Mm.
thank you. Ms. Fiesel, I think that's all the questions I have for you. So let me see if there's any follow-up or any redirect on Commissioner questions.
Out of an abundance of caution, the exhibit that I passed out, it's public record, but I would like to have that marked
Okay,
as public staff, Fiesel, redirect, exhibit.
Exhibit 1.
Yes,
Mhm.
and admitted into evidence.
Okay, without objection?
Part of a commission's order. I don't see why you have to do that, but no objection.
No objection.
Out
All
of an
right,
abundance of caution.
all right. So without objection, that will be so admitted as public staff Fiesel redirect Exhibit 1.
And
All right.
Somebody would move introduction of WRI Diesel exhibit, cross-examination exhibit number 1.
All right, and without objection, that will be so marked and identified into the record and accepted as evidence. So with that, Ms. Fiesel, you are excused. Thank you for your testimony today and yesterday.
Well, I just wonder when the commission's gonna have its morning break.
We, is Mr. Finley, are you asking that we take it now perhaps? Because we can do that now?
Give us a chance to touch base and be prepared for the rebuttal.
Absolutely. We'll take a 10-minute break and come back a minute after 11. All right, we're going off the record. Thank you. the record. Mr. Finley, you have your witnesses up. Let me swear them in. Mr. Abbott, I'll remind you that you're still under oath from your previous swearing in. All right, y'all ready? Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I will.
All right, thank you.
Thank you.
Ms. Perry, will you identify yourself for the record, please?
My name is Julie Perry, and I'm a principal consultant with Peden and Perry Consulting.
Right. Ms. Peden, will you identify yourself?
My name is Darlene Peden, and I am a principal consultant with Peden and Perry Consulting LLC.
Mr. Abbott, you've already identified yourself and been subject to cross-examination once, right?
Yes, sir.
Madam Hearing Examiner, we would, let me ask you, the three of you, these questions. Did you cause to be pre-filed in this docket rebuttal testimony and question and answer form consisting of 32 pages?
Yes.
Yeah,
Yes.
Are there additions or corrections that you need to make to your pre-filed rebuttal testimony?
I have two corrections. One is on page 24, line 1. And the date should read May 2024.
I'm sorry, repeat that page number.
Page 24, line 1. And the date should read May 2024.
Okay, thank you.
The second correction is on page. Don't have a second correction. I think my tab got messed up. Give me 1 second. I had it tabbed and I think my tab has jumped off the page. So now- I can't find it. If I discover it, I will be glad to let you know what page it's on.
Yes, that'll be fine. You can, we'll accept that once you find it. Thank you.
Okay. If there is another error, I had it tabbed and apparently it's not sticky enough to stick to the page, so.
Okay, you can let us know. Thank you.
So I will ask you if the if the questions, the direct pre-file rebuttal testimony were asked of you today, except for that one correction and the missing correction, would your answers be the same?
Yes.
yeah.
Yes.
Madam Hearing Examiner, we would move that the rebuttal testimony of the three witnesses be copied into the record as though given orally from the stand.
Without objection, that will be allowed.
Now, we have a few additional questions to ask the panel based on some of the testimony that we received yesterday and that we did not anticipate if the chair will allow.
Ms. Holt, without objection, just to clarify the record,
What is it about? I'm sorry.
It is, in particular, it is about the testimony that Mr. Hauser gave that had nothing to do with his direct testimony about the delay that he maintained existed, having to do with the early period when there were problems with well number 1 and the actions that the company took. He maintained in his testimony for the first time that that was not proper activity that it took or failed to take.
I'm sorry. This is is he correcting something that he said?
No,
Rebuttal?
no, he is adding, we, testimony came out yesterday that was not in the pre-file direct testimony that we heard for the first time about the reasonableness and prudence of the company's activity with respect to well number one. And I think it's commission's practice to allow the rebuttal witnesses to address those types of issues when they come up and when they were not anticipated. We couldn't have filed any rebuttal testimony to it because there wasn't anything to rebut until now.
Well, council had an objection to the public staff opining on additional information and deemed it surrebuttal. So based on that same objection, I object to, I mean, you can ask him on redirect to clarify information.
And I'm going to overrule the objection there and allow Mr. Finley to have this clarification of testimony because that information was received into the record yesterday after the objection of Mr. Finley. So we will have some clarification on that, but it will be brief.
And the other thing we would like to do, Madam Hearing Examiner, that there's been a lot of talk about this interconnection point with the town of Harrisburg, and we have some pictures that we would like to present for illustrative purposes, just so that people will be able to see what we're talking about.
Okay, if you will show a picture, or you'll give a copy to council and a copy to myself.
Council would need to object to these. No foundation has been laid. We don't know when these were taken, these pictures were taken. Our witness has not had an opportunity to examine them.
Well,
Our engineering witness, Hauser. So I object to them.
Mr. Finley, would you lay foundation of when these pictures were taken and as you?
be happy to do that. And again, this is for illustrative purposes, just so we can see what we're talking about, I think. So panel, tell me when these pictures were taken, please.
Just gonna give you a date.
While I'm looking up the date, I will tell you that Mr. Hauser did view these exact items that are in this photo when he did his field examination. We went to where this interconnection is, and everything that's seen in those photos, Mr. Hauser has seen with his own eyes and more, because the vaults were open for him to inspect as well.
We're going to give Mr. Hauser a moment to review, and then we'll hear back from you, Miss Public Staff, Miss Holt.
These pictures were taken November the 6th, 2023.
Did you take these pictures, Mr. Abbott?
I did, yes, ma'am.
Okay.
We don't object to these pictures.
Okay, thank you. Please proceed, Mr. Finley.
Let's have those marked for rebuttal exhibits number 1 for illustrative purposes only, just so we'll know what we're talking about.
So we're going to call it WRI Rebuttal Exhibit 1. And it'll be so marked and identified in the record for illustrative purposes.
Now, Mr. Abbott, you were in the hearing room yesterday when Public Staff Witness Hauser testified about the discontinuation of well number one on your system and the replacement of that well ultimately with the interconnection with the town of Harrisburg, will you not?
Yes.
And as I heard his testimony, he suggested that in the early period, when there was difficulty with well number one, it's his view that you should have acted more quickly. And had you done so, perhaps some of these legal fees that we're talking about, I guess that was his point, would not have been incurred when they were. Could you address that, please?
Sure. So first, I think it's important to note that we received notice of a violation in December of 2018. So I want to make sure that everyone, when we talk about 2018, we're not thinking this was January or it was a full year. It was really, I believe it was December the 17th of 2018. So it wasn't even a full month. So if we want to talk about a timeline, that really, you can look at it beginning in January. Second point I'll make is when we received this notice of violation, we immediately reached out to DEQ because we realized the seriousness of this violation. It was not of our doing. Radon is a natural causing event that happens in rock formations, and radon can get into groundwater through soil and also decaying rocks. It's not from a lack of proper operation of the system or maintenance or anything like that. So we were in constant communication with DEQ and how we would move forward in addressing this. Felt like they were good partners in guiding and directing us and working with us on what our options were. So again, when Mr. Hauser says we weren't acting prudently, we were. We were doing the right thing and having conversations with the state regulatory agency in how we went about doing this. What we learned was that we could, as a result of a failed test, and by the way, the violation letter said that our levels were at 6 and we were only allowed 5. So we were just over the allowable levels according to the letter we received from DEQ. Once you have a failed test, you have to test once a quarter after that. And in that period of time, they will average over the next 4 samples over that quarter whether or not you can come back into compliance. And so that's what we were intending to do in discussions with DEQ. When it became evident later on in 2019 that we were not going to be able to come back into compliance by following that method, that's when we began looking at other alternatives to correct the situation. One of the alternatives that was presented to us by our engineer is you can actually combine the readings of 2 wells. If you mix the raw water of both wells together, you can look at the combined radium levels of those 2 together. We knew our other well had very low radium levels, even though this one breached the allowable limit. But we thought maybe by mixing the 2 together, that would lower the total radium level and bring us back into compliance. So there was some time spent with the engineer taking a look at that and studying that. And ultimately, we decided that that was not going to be a viable option for us either. So we then looked to the town of Harrisburg and the possibility of tying into the town of Harrisburg. My first contact with the town of Harrisburg was in the summer of 2019 to start the tie-in and begin the tie-in process. It wasn't until, after many attempts, until November of 2019, there actually got a reply from them stating that yes, they had the capacity, they could serve our community. And so once I got that okay, then I could move forward with spending money on engineering surveys and start the process. We began with looking at, we have 2 entrances to these communities. At both entrances, there's a water main stubbed out to the main road, which is Rocky River Road, which is where the water main for town of Harrisburg is. And what I preferred was one particular entrance that after engineering work was looked into it and done and surveys conducted, was decided by engineering that was not a viable option. And so we had to start over and we looked at the second entrance. And that's when we decided that was the entrance that we would pursue for this tie-in. So, and from that point forward, we continued to move down that path, and we realized as a result of that survey and the engineering work, we had to have an easement. I thought that we would be able to just take that line and run it straight down the utility easement, go across the road and tie in. What we learned is that was not possible, and we were going to have to go across an individual owner's property, and we had to get an easement. And things really came to a very slow stall at that point in time in trying to secure an easement from the homeowner, who was unresponsive to us for quite a few months, despite phone calls, emails, and letters. She just wouldn't respond. Ultimately, she did respond and say she wasn't interested in providing us with an easement, and redirected us to her neighbor across the street, which wouldn't work for us because that was the opposite side of the road that the water main was on. By now, we're in the middle of a pandemic, and getting things done really slows down. It's difficult. The economy shut down. Getting engineers to do work and all the things are implied with the pandemic and an economy shut down. Water Resources was not exempt from the pandemic and the things that impact businesses operating during a pandemic. And that was a big part of the stall in 2022, in 2020, that caused us some problems. We were ultimately able to secure the easement through, as I testified yesterday, after engaging with an attorney and threatening to condemn the property. And she ultimately came to the table, made some pretty, what I felt were outrageous demands, but we weren't in a position to let this project stall anymore. So we paid what we believe was double about what we should have for an easement, plus some other stipulations she put on it. So we could continue moving the project along. So all along through this, we had a number of issues. We were in communication with DEQ. We were giving them quarterly updates as to what we were doing along throughout this project. In all of this, nobody knew when the pandemic was going to end. So our projections didn't anticipate that the pandemic would drag on until, I think officially it was over April of 2023 is when the pandemic was officially termed as over. And then coming out of the pandemic, there would be a shortage of supplies, materials, for us to be able to buy the materials in order to start the construction. Also coming out of the pandemic, as the economy ramped back up, there was a high demand for contractors and construction work that had been stalled during the pandemic. This is a very small project. We contacted a lot of different contractors and ultimately only had one that really was willing to enter into a contract to do the work. Many of them went dark on us after initial conversations. The job was just too small based on the amount of work that they had going on. So in all of this, while we were moving forward, we could just continue to consult with our engineer. We also explored expanding our green sand filter to remove the radon from the water. There were conversations with DEQ about that option. Those were informal conversations, but again, throughout all of this, we continue to have conversations with DEQ and trying to keep them up to date on what we were doing about the issue and getting their guidance and direction. On the green sand filter, the DEQ engineers didn't like the fact that that would cause us to have a backwash of the filter that would discharge basically the radon particles or filter media that have been used to filter out the radon and discharge that into the wastewater system for the city of Concord. They weren't comfortable with that piece of it. And so as a result of that, we had to abandon that option as well. And so it took us back to the town of Harrisburg in that time. So that's a brief summary to tell you, there's a lot more detail. We could spend 2 hours talking about it, but that's a high summary of what caused the delays. But the core of all of it was the pandemic that none of us can control. And we all know the impact that had on the economy here in the United States.
All right, thank you, sir. We passed out we understood from the commission that you were looking for summaries, so we prepared a summary for this testimony, but in light of the time constraints, as occurred yesterday, would ask that that be copied into the record as given orally rather than have the witnesses read the summary.
Without objection, that will be allowed. The summary will be copied into the record as if given orally from the stand.
So the rebuttal witnesses are available for cross-examination.
Does this summary include what, Mr. Abbott, additional testimony he made today?
No, ma'am. The summary was provided at the request of the commission before we came into the hearing yesterday, and we weren't expecting that testimony from Mr. Hauser, so we couldn't have possibly have provided that in the summary in the time constraints allowed.
I'm sorry, this is a summary of his rebuttal testimony.
Correct. If Ms. Holt wants to review the summary and look at it, that's fine with us.
Yeah, do you need a few minutes?
Yeah, just a minute.
We'd be happy to have the witnesses read it if that's what the public staff would like.
Rather it be read, we can certainly do that. You can let us know.
Did the company make any changes or additions to its summary that was not in the testimony? We found one area that wasn't in the testimony regarding rate design.
Ms. Holt, if you'll take a minute and refer us to what your, point us to where you're questioning.
Oh, okay. You added some information regarding the 3565.
Yeah, that was in our testimony, but we are agreeing, so I think one of the things for our rebuttal is, because there's no way to do this sort of rebuttal thing, is that we were kind of acquiesced to on the stand that we would, do a 3565 instead of a 4060 that we had, 3070 that we had filed. And we had cited in our rebuttal that, Aqua and Carolina Water had some similar rate designs as well. And I think that was all we were trying to say, was to help customers out in this. We're just trying to, I think sometimes your position does change, and we're going to have to probably explain some things on the stand today that we've heard since, since we filed and since you guys have filed. And so that this is us just saying, we know rates are going up, and we're willing to help the customers by going 3565 if that helps the position.
And I want to say one thing too, and I don't want to over talk. That's one thing I'm trying not to do, but we did recommend 4060. The public staff in its testimony recommended 3070 rate design.
Certainly. Can we take a break, please, so we can review this?
Absolutely. We'll go off the record for 10 minutes,
Okay.
and come back on at 11:35. Thank you. Back on the record, and we're with Ms. Holt, ready for cross-examination of these rebuttal witnesses.
Yes, thank you. Public staff reviewed the summary of the rebuttal testimony that counsel asked to admit into evidence, and we would move to strike as it not being totally representative of the rebuttal testimony. We found additions, additional verbiage that was not discussed in the rebuttal at all as to the pump, the level of salaries, regarding rate case expense, rate design. That's certainly an addition. So we would just move to strike the whole thing.
The whole thing, okay, well, let me ask you this, I mean, were you speaking to just a minute ago specific bullet points, or you're thinking the whole thing is, you're moving to strike the whole thing, but are you,
Well, I don't see how you can, I think I would recommend move that the company resubmit it perhaps and limit it to the rebuttal testimony without any additions. There were significant additions, and I don't see how today we can just go through it and redact certain portions. We haven't done a very exhaustive review of it, and
okay,
we might miss some things.
okay, all right, so.
Madam
Mr.
Chairman, I
Ford?
would ask that the company make, the public staff make its motion to strike in greater detail than what it has done today. But I will say that we heard yesterday and today a quite expansive list of things that were not in the public staff, that actually changed in great magnitude the cases that we prepared for to come here today. So if they would please identify what they want to strike and give us an opportunity to respond to it. And if you would take that under advisement, we will request that.
Certainly, and I might add that council prompted the responses that it did through its questions of the public staff's witnesses. And the company could have requested to update its rebuttal testimony rather than add things, additional information to the summary. Thank you.
Ms. Holt, when you say, the company could have asked to update its rebuttal testimony, do you mean in a pre-filed manner?
Yes,
As opposed to today on the witness stand?
that's correct.
Okay, all right, thank you.
It's pretty hard to rebuttal that you, to give rebuttal testimony that you haven't heard in advance of the testimony being presented.
Duly noted, Mr. Finley. Okay, so what we're gonna do, we are going to, ask that, in regards to Ms. Holt's, request that we, strike this, summary because it includes more than what was in the rebuttal testimony. So she doesn't have, a chance right now to, actually pinpoint specific items. Public staff is just aware that there are some. The public staff may, request to strike that, as they've had time to review it and can seek, from the hearing examiner, a ruling on that. And so for now, we will, admit the summary into the record, as if given orally from the stand, but we will be waiting for the public staff's, I guess that's proper procedure, Ms. Holt's looking at me, to strike, certain, components. Or, let me do this then, let me just backtrack for just a moment. Let's not enter this into the record right now. And let's, give the public staff an opportunity to, provide their, items that they would like to strike. And then the hearing examiner will admit those portions based on its ruling.
Thank you.
Okay.
That would be our preference.
Thank y'all. Thank y'all for your patience on that. Okay, now you may proceed, Ms. Holt, with the cross-examination of these witnesses.
Sorry, one other thing.
Yes, Mr. Finley.
Ms. Peden has found her second.
Okay, thank you. We'll take that, Ms. Keating, at this time.
Yes, thank you. It is on page 32, the last page of the rebuttal, line 14. And that docket number should read W-218 sub 573, not 873.
Okay, thank you. We've got that noted.
All right, thank you. Good afternoon.
Still morning.
Oh, is it morning? Still morning. All right, good morning. Let's see, Mr. Abbott, I'd like to go back to your, revisit your testimony regarding, what you encountered after December 2018, when you received notification of the violations. You note that you went into the middle, of a pandemic and couldn't do any work. What specifically couldn't you do during the pandemic?
Well, we had difficulty engaging people to do the work that needed to be done as far as engineering work, preliminary work and surveys and that type of thing to look at getting the tie-in done. All of those were either typically drawn out to get somebody to do that because they have very limited workforce, obviously, to go out in the field and do things.
I didn't know that they weren't exempt from some of the COVID moratorium. Engineers and that sort, people.
Well, engineers aren't obviously government employees, but there's a lot of individuals who opted not to go into the office, opted not to work as teams out in the field during that time. All companies really were in a position that if someone, I can't speak for them, but if you have an employee who says, I'm not comfortable leaving my home to work in this environment, companies really weren't in a position to say, well, no, you got to report to work or you're fired. You just weren't able to do that during the pandemic.
Okay, certainly. Now you state that coming out of the pandemic, you continued to consult with engineers, and then you had informal conversations with DEQ. With whom did you have conversations?
We had conversations, most of our conversations were Harris Ali and Clinton Cook.
Okay. And during what time period? Were these consistent conversations from what time period?
Well, once we got the violation, we engaged in dialogue and also emails on various items. We emailed them on the quarterly updates, but we had telephone conversations on a regular basis, starting right after the violation, which was December 17th of 2018.
Okay. So were you having conversations between up until February 6, 2021, when you received a penalty of $4,500.
Yes, ma'am.
So notwithstanding your communication with these DEQ employees, they assessed you with a fine.
Yes, ma'am. They were put in and there was actually a phone call to me prior to levying the fine. So look, we're in a rock and a hard place. We're only allowed to give you a 12-month extension. And that's all we can do. And after that, we're forced to turn it over and take more harsh measures. It's out of our hands. It's a DEQ policy. We understand the situation you're in, but this is something we want you to understand we have to do. And so those were the types of conversations we were having. And so they actually told us that they were going to be levying that before they sent us the letter and said, just understand, we know you're doing what you can and given the circumstances, but our hands are tied on this.
Okay, and you were in conversation with DEQ when DEQ filed a complaint and motion for injunctive relief against you?
Yes, ma'am. Again, there was a phone call prior to that ever happening. We had a conversation. They said, remember, I told you we could give you a 12-month extension. And if we couldn't get things done by the end of that 12-month extension, we would have to turn it over to DOJ at that point in time. And said, so our hands are tied. We can't be involved in, this is a required step for us to take the next step. And so, yes, there was conversation even up until that point.
Right.
And there was conversations, they were at the court appearances as well.
Mhm.
And we would have conversations there. They were very amicable and empathetic from their side, but they were doing what they had to do and they were required to do, and I understood that.
Their position is non-compliance is non-compliant.
That's correct,
Okay,
regardless of the circumstances.
okay. Did you request any relief in writing during this time period?
When you say relief,
Or did you provide an account of your circumstances in writing during this interim? Before the fine was imposed and before the complaint was filed?
no, not in writing. I mean, I think everybody knew we were in a pandemic. I didn't think I need to document that we were in a pandemic and causing a lot of these delays.
Okay, thank you.
Be sure to speak up into the microphone there, Mr. Abbott, so everybody can hear you.
Yes, sir.
Hey. Sorry, Mr. Abbott. Okay. Mr. Abbott, how much does your water bill run on average?
At my home,
Yes, in your home.
my average water bill is about $250 a month.
Okay. And that's just water only?
Yes, ma'am.
Okay,
Excuse me. No, I take that back. I'm on sewer as well.
okay. Do you live in the subdivisions that you serve?
No, ma'am.
Okay. Would you find it to be extraordinary if your water bill went up 384%?
Well, it depends on the circumstances for that increase.
Okay.
It would certainly cause me to ask questions as to why. Is there justification for this increase?
And do you think you provided such justification to your customers?
I do. Yes, ma'am.
Do you think the situation that the company faced, with the well going bad, et cetera, and needing to obtain a connection to Harrisburg, could be characterized as an extraordinary event.
No, I don't know that it's extraordinary. Otherwise, DEQ wouldn't require monitoring for radon in wells. You know, that's a regular monitoring. Clearly, they want to make sure there's not an event that would happen that would cause radon to be in the potable water supply we're providing. And so I wouldn't think they would ask us to monitor for that if it would be considered extraordinary that there would be a problem there.
No, but resolute, what you had to go through to resolve the issue.
Well, regardless, I mean, there had to be a resolution to the problem. And I don't want to talk to symptoms and you have to go to root cause. What is the root cause? And the root cause is no one's fault that there's radon now in the groundwater we're pumping to serve our clients that we didn't, obviously no one wants to provide them. And regardless of what the solutions were, there were three options. One was to drill a new well, buy land, drill a new well. Couldn't find any land in the area where we could tie it back into the water distribution system, anything close by. The second option was, four options. Second option was the green sand filter, which I spoke about earlier. The third option was to combine, to mix the water from both of the wells together. And then the fourth option was town of Harrisburg, tying that in. So three of the four were eliminated. That only left the town of Harrisburg tie-in as the viable option.
Was that the last resort option?
It was for us. We wanted to pursue other options. We knew it was an option from early on, and
Mhm.
because we knew we would be dealing with a lot of, for lack of a better way to put it, government agencies and red tape and approvals from multiple state agencies. We were concerned it would take also the longest amount of time to get done. And so we continued down that path while we're exploring the other options as well. But we really explored all of our options all simultaneously at the same time. But it was, at the end, it was the least preferred option.
Um, in recognition of the fact that you had to do what you had to do, is this still not a considerable increase on customers?
No, it is a considerable increase on customers. There's no ifs, ands, or buts about that. They also currently, and have for many years, enjoyed some of the lowest water rates in the state of North Carolina.
And are you familiar with the term rate shock?
I would assume that means the same thing as sticker shock. You gotta buy a
Exactly.
car these days.
Exactly. Exactly.
And I understand it. I'm very empathetic. I do understand that would cause rate shock. And, you know, I've been a very empathetic operator of our water systems. I've done everything I can to keep their rates as low as I possibly can for many, many years. And as much to my expense and my reputation, I have been accused by public staff of being a rogue operator. Which I'm not. I'm very responsible. I've tried to operate a system as cost efficiently as possible, knowing that to do otherwise would mean an increase in rates. to my homeowners. So I kind of feel like I'm damned if I do and damned if I don't. In this particular situation, I had no choice. This was something I had to do, and I knew that doing this, I needed to get a return on the money. I mean, the dollars are the dollars. We provided invoices in support of what we paid. I've lost, from an operation perspective, another $150,000. In the last several years, I have personally put $600,000 into this system and operating this system. And a great expense to me. So should I be allowed to recover that through rates? According to statute, yes. And that's all we're trying to do here today. It's not my customer's fault, nor is it my fault. It's no one's fault that radon entered into the groundwater source. That's just a natural occurring thing. But something had to be done. And the regulatory agencies did their part in holding my feet to the fire, much to, quite frankly, in private conversations, their empathy. We understand you're doing all that you can, but we have no choice.
Right.
And we know this is quite frankly not our favorable path, but we have no choice to go down this path. And I said, I understand. I don't take it personally, and you got to do what you got to do. I'm doing everything I can. So all of this was a very unfortunate set of circumstances, all set in motion due to no one's fault. And unfortunately, I've had to pay for it. I've had my reputation and my integrity questioned in public, in private, and my clients and my customers, they're going to have to pay higher rates as a result of that, so we can recover this tremendous amount of money we've put into this system.
Have you, you've been here when Mr. Finley mentioned the 2017 Duke Energy rate case where Mr. Junis testified?
Yes, ma'am.
Are you aware that both the 2017 Duke Energy Progress and the Duke Energy Carolinas rate cases were reversed and remanded in part because the North Carolina Supreme Court determined that the commission did not properly consider and make findings and conclusions concerning all material facts as required under 62-133D?
No, ma'am, I'm not familiar with the details of the case.
Or would you accept, subject to check, that is a fact?
Yes. Yes.
I'll move on. Are you aware, I'm sorry. That a number of your customers are very dissatisfied with the company and have filed formal and informal complaints, sent in numerous customer statements, testified at the customer hearing where you were present, and even signed a petition to remove Water Resources as operator?
I'm not surprised, but the issues they brought to the table, in my opinion, are old issues that have been resolved.
Old issues like what?
Well, they talked about poor customer service. It was one of them, for instance. That came to light to us that we had an employee who wasn't doing what they should do and timely returning phone calls. And we immediately terminated that employee. Since that time, that hasn't been the case. In fact, I did find it interesting, Mr. Hauser's written testimony that he's talked about the complaints that have been received by the public staff, but we know that there have been some customers also sending some complimentary emails to the public staff about the change and the improvement in the customer service that we provided, but he didn't speak to those items. So it seemed that he was trying to provide a slanted view. So we have improved that and we've corrected that. And we keep, as we've turned in the customer logs as we're required to, I think that's reflective in the customer logs. Most of our calls are questions about a bill. Other questions, if it's about the service, or concerns or low pressure, for instance, we respond to those very quickly and correct those. Obviously, during an outage, you're going to have a lot of phone calls during an outage, and we understand that.
When the petition, and I might add that the petition to remove water resources was filed as an exhibit to Mr. Lenny DeVito's statement
Yes, ma'am.
and admitted into evidence.
Mhm.
When this petition was filed and this led to a news investigation a couple of times, do you recall that?
Well, it wasn't because of Mr. DeVito's petition. That was due to a resident who claimed that we hadn't responded to a leaking water meter that he had on his property. That's what the news stories were about. And Mr. DeVito has been a long critic of water resources. So it didn't surprise me that he filed that petition. As you well know, that there was an investigation, and public staff did not recommend that our certificate of convenience and necessity be revoked.
Can I add something to that?
Sure.
If he were to be removed as the operator, the commission would have to find an operator and, you know, be subject to, you know, have to find an emergency operator, to operate the system. And these costs would be imposed on those customers anyway. We don't want the rates to go up any more than anybody else does. It's just a fact of the case. But there would be other proceedings that would be costly to, if he were removed. And he has been, you know, used his own resources, and he has not walked away from the system. And I'm sure there are probably times he may have wanted to.
Mhm. At any time, Mr. Abbott, did you contact the customers and explain your situation? Explain what you were going through, explain the delays that you encountered in replacing the well number 2? I'm sorry, well number 1?
I have to go back and look. We did send out some correspondence about a couple of times about some things. We did notify them when as required by statute, when well number 1 was exceeded the allowable limit for radon. We did notify them then, and we did notify them that we were taking that off of line, that well off of line. I don't know that we did on a regular basis, but periodically. We didn't see that it impacted them per se on an ongoing basis unless there was an outage. And so dealing with that didn't directly impact them, even though folks were aware of it, because we did make them aware that we were pursuing a tie-in with the town of Harrisburg, but I don't know that we gave them regular updates on the progress of it.
Okay. Do you not think that the threat of the ramifications of having only one well in violation of state statute doesn't warrant concern. Do you think they actually have to be customers actually have to be impacted in order to have concerns and to complain?
No, I think we had made them aware of the situation. I think what you're asking is, did we provide them updates about the tie-in to the town of Harrisburg, and not on a regular basis? I think we sent out a couple of letters and made them aware we were continuing to work on it, but it met some obstacles and some unforeseen delays. But so from that perspective, we communicated with them in that regard. But it was known in the community, residents knew that. We were pursuing that tie-in, yes.
Right. But didn't they have valid concerns during the interim? You gave them notice, let me read.
I think they had the same concerns that we all did, that we needed to get this remedied. And certainly, their concern was no different than mine or anybody else's, of trying to move as expeditiously as we possibly could to remedy the situation. I certainly understand that. I was concerned and understood that they were as well.
Because you would concede that after you notified customers, I imagine in 2018, 2019, and then you inform them this is the situation, you'll have to resolve the situation, correct?
Correct. Mhm.
And then it takes 4.5 years for it to be resolved.
Well, they're not living under a rock. They know there was a pandemic and what all was going on with the economy being shut down in this country. So they understand things are moving pretty slowly.
Certainly, but with all due respect, pandemic wasn't 4.5 years.
Pandemic started on March 15th, 2020 officially, and it wasn't over officially until April of 2023. So it's 3 years.
Okay. I'll go on. I'd like to hand out an exhibit. That I'd like to have identified as public staff panel cross exhibit 1.
Okay, it will be so identified. Public Staff Panel Cross Exhibit 1.
And Mr. Abbott, I'll give you a minute to review this. It's entitled Site Visit Report for Rocky River Plantation, dated March 29th, 2018. Would you agree, Mr. Abbott, that this is a site visit report from DEQ's Public Water Supply section
Yes, ma'am.
on this date, March 29th, 2018? And could you please read the first paragraph of the comments from the site vision section on page 1?
The water system is not operated or maintained in accordance with approved plans and specs. The approval letter for project 897189 states that well number 1 and well 2 will be operated separately, with an alternator. Well 1 can only be operated manually. The motor on the pump in well 2 is not functional.
Okay. Is it your understanding from this document that Rocky River Plantation well 2 was offline at the time of DEQ's site visit on March 29th, 2018.
No, ma'am, she had inverted the well numbers. What she referred to as well 2 is actually well 1.
Okay. May I object for clarification? Does this have to do with the legal fees we're talking about here, Ms. Holt?
This has to do with the condition of the system.
For what purposes of your recommendation?
When the company knew what it knew about the compliance of well 1 and the length of time it took to remedy the situation.
Well, but I'm sure, you know, we've drifted so far. We started off with issues about legal fees. And that was the recommendation of the public staff. And my question, I tried very carefully to say, you don't say in your testimony this, that, or the other. But then primarily from the chair, from questions from the chair, we got into the reasonableness and prudence of this well number 2. I mean, we're going to have a whole different case. We need to sort of know about that in advance. The recommendations of the public staff do not have to do with reasonableness of the costs, the recovery of those costs. As far as I'm concerned, it doesn't have to do with service after having read the report from the customer testimony.
With all due respect, it is position of the public staff that there were substantial delays, unreasonable delays in rectifying the system and making needed repairs, which led to increased costs. And this line of questioning pertains to our position.
Increased cost in the rectification of the situation or legal fees?
Both. They're connected,
Are you now making,
which I will get.
are you making recommendations that part of the $470,000 costs for the interconnection should be disapproved when you didn't make that recommendation in your testimony anywhere?
We are not.
Okay.
Okay, we're going to proceed with this line of questioning. That objection's overruled.
This is pertaining to well number 1, correct?
Right, she's referring to both wells, well 1 and well 2.
Okay. And do you dispute the observation of DEQ regarding well 1?
I do.
You do?
I do.
Okay. In what way?
Well, Meredith was a new engineer for DEQ, if I recall correctly. And she was replacement for an engineer named Paul Judge, who had been the engineer for that site for many, many years. God rest his soul. Unfortunately, Paul died a tragic death. Paul had given me permission. Let me back up. So from well number 1, which is approximately 100 yards from well number 2, across the street, and there was, when it was originally constructed, not by our company, but from the original operator, they had run electrical wire from well number 1 all the way up to well number 2 and the controls. And that signal, that wire was to send a signal to well number 1 to come on or off based on the equipment that was there to monitor pressure and telling the wells when to turn on and off and that sort of thing. At some point, that electrical wire was cut during construction of a home. Paul Judge took the position, and I have an email from him that I can dig out if I have to, because this was back in probably 2014. At his suggestion, he said, why don't you, I am okay with you just operating well number 2 as a regular well, and you only use well number 1 for emergency purposes. You still are in compliance with 2 wells, but you only have, so in an emergency situation, you can manually turn on well number 1 in order to provide you with the supply you need in emergency situations. That was Paul Judge, field engineer for DEQ. That was his position. Again, I have an email from him. I provided that email to Meredith when she sent me this notification. And her response was, I don't care that that's not according to plans. I said, but I have an engineer from DEQ that's changed that approval and given me approval to operate it as it is. And she said, I don't care. That's not according to the original plans that were approved. And so I'm directing you to return that well back to full service.
Okay.
So in my mind, I was operating according to what was approved by DEQ and the field engineer had approved. Mr. Paul Judge.
Okay. Do you recall when the first sample above the radium standard was?
I'd have to go back and look. I know when the violation was issued to me. The violation was issued on December 17th of 2018.
Okay, was it May of 2018?
Be honest with you, I don't know because I have a contracted operator that was pulling those samples. So I don't know. Without referring and pulling up the lab, all the lab tests. By the way, if I may say, not long after receiving this report that you gave me, I fired that operator and hired a new operator because I did not find this acceptable.
I'm sorry.
The
You filed
contracted
an
operator I had at the time,
Okay,
he and I separated ways and I hired a new operator because I didn't find this acceptable.
you did not find what acceptable?
I didn't find that an inspection like this is acceptable to how we want to operate our systems.
In light of the existing issue with only one well active, at least as early of March of 2018, with, according to what we've seen, radium levels above the MCL beginning in May of 2018, and the subsequent enforcement and legal actions of DEQ and DOJ, I'm sorry, is it reasonable that a reliable source of supply with adequate flow was not functional until December of 2023?
No, ma'am, I wouldn't agree to that. The testing, you do a series of testings because you can have one test that's an anomaly that doesn't represent what the regular occurrence of radon in the water may be. So that's why you do a series of tests. And in this particular case, that's why if you say that's when I took the first sample, a violation wasn't entered into until December to say you're in violation.
Mm-hmm.
So you can, and that well was available, it was operational. It was just, again, according to what Mr. Judge had agreed to, was only to be used for emergency purposes. So it's fully operational. But because of, and I can't pronounce her last name, so that's why I refer to her as Meredith.
Mm-hmm.
Guglielmi, I think is maybe the way you pronounce it. it was at her direction that it be brought back on full time. And it was her direction that said, you've got to go through like a full battery of tests, just like you've never had that well online before. And go through all of that. So we were following her direction on what to do here.
Okay. Um. Isn't it true that the test results though started trending up? And for specifically each of the next 2 quarters.
They did, and then after that, it trended down. Tests that were taken in 2019, they actually trended down from what it was earlier. So that's my point being is these samples can go up and down. And that's why you do a series of them and they average them together.
Okay, so did they trend down after the violations?
They did, but they didn't trend down enough to come in compliance.
Okay, all right, thank you. Is there a specific period of time over which the town of Harrisburg will supply water to the Rocky River system?
They haven't given me any. That has never really been discussed with them, to be honest with you.
So there's no expiration date on how long you can use the interconnect?
They haven't given me one. Do you know how politicians can be? They can change that policy or whatever they want to do with an election. So, but there hasn't been anything discussed with me about it one way or the other.
But what was your expectation when you entered into the agreement?
As long as I pay my bills, I can have access to the water supply.
Okay, indefinitely.
But there's no contract that says that. Yeah.
Okay. Can we have a short break before we wrap it up?
Yes,
Okay. Sure,
the record. Thank you.
thanks. The public staff has no additional questions.
All right, thank you, Ms. Holt. Mr. Finley?
A few questions. Mr. Abbott, you were asked a lot of questions about what your bill is in Charlotte and whether it's high or low and the impact on customers and water resources of a big increase and rate shock and that type of thing. Do you call those questions?
Yes, sir.
Is it not a fact that one of the determinants that determines any particular customer's bill is the rate design that the company has to assess those customers?
Yes, sir.
And some of the costs are recovered through a monthly charge that is fixed, and some of the costs are recovered through a usage charge. Is that right?
Yes, sir.
In your opinion, what is the fairest way to split out those costs as far as the ratio between fixed recovery and usage recovery?
Well, I believe it's a 40-60 split is a fair split between those two.
Why is that?
Well, the rate base at that level gives us what we believe is a proper return on what we've invested to improve the system. And then the 60% gives us a return we need for continuing operation, normal operation, repeating expenses that we incur in operating the system, and also meeting regulatory requirements.
Again, you were asked questions about the period over which the radium levels were being identified as being high in the communications with DEQ and the notice of violations and all that type of thing, correct?
Yes, sir.
And were you not going without the revenue that thought you needed to run the system during that period of time?
Yes, sir. Just even on the operational side, we did not have enough revenue coming in to meet expenses. And so I was personally investing personal funds to continue to meet those shortfalls. In addition to using personal funds to provide revenue to make these capital improvements that were necessary.
All right. And so there is going to be some, what we can legitimately call rate shock, correct?
Yes, sir.
But part of it is based on where we're starting, the level in which you're starting and what you're coming up to, correct?
That's correct.
And you're not asking the commission to do anything but allow you to recover the legitimate cost under the North Carolina general statutes that you're entitled to in this case, correct?
That's correct. Yes, sir.
And you were at the hearing in Charlotte to hear the customers.
Yes, sir.
And what will we hear, 19 or so customers?
19 sounds like the right number. Yes, sir.
And you filed a report,
I did.
and the public staff reviewed that report and filed their response to it, right?
Yes, sir.
And they took some issue with some of the things you said, but by and large, not.
That's correct.
No further questions.
Okay, and I have just a few questions for the panel. First, Mr. Abbott, I think you were going to give me some clarification regarding the pump that got replaced because it was hit by lightning.
Yes, ma'am. What would you like to know?
Okay, so there seemed to be a lot of testimony about that. So that the pump had just recently been installed. I think it was in 2022, and then it got replaced in 2023.
Yes, ma'am.
I think it was several $1,000s pump, maybe 15,000. Okay,
15,000
okay.
thereabouts.
So it's a pretty good amount of money that had only been in service for a short period of time.
Yes, ma'am.
It was hit by lightning, but it was not, you were not able to recover insurance from it, as I understand.
That's correct. Yes, ma'am. It was not under warranty it's not covered by warranty in the lightning, and I wasn't able to recover it in insurance either.
Okay, so and so what did happen to the pump? It just
It was
got
disposed of.
disposed of. Okay, it was,
And if I could add to that.
yes.
To be, there was a data request that they cited yesterday that you guys have, as public staff redirect, anyway, exhibit 1. This was a one-day turnaround on this data request response. So if there was an error in the tweaking of the language, and it basically said the warranty would apply, it would not apply. Basically an act of God, and I think almost everything I've ever read when it comes to these warranties, if an act of God, which such as, just happened with lightning, they call it an act of God, there is no warranty for that.
Okay,
Okay, and so that was, I will take the full responsibility for that one. That was a typo, but given sake, we were trying to get this turned around to the public staff as soon as we could, and we promised we would, and we did. But I apologize, we didn't do a very good job of reviewing. So
okay,
that is what the Gopher guys told, or whatever the guy's name.
Gopher.
Gopher, can't remember what his name was, told us. And so, told Beth, and so
okay, that helps a lot. That
Yeah.
helps tremendously, because I was
Yeah,
just confused
that was-
there.
that
Okay,
was my editing error.
okay,
for
all right,
non-union.
okay, that helps. Thank you for clarifying. And on the salaries and wages, you were in the room when I asked, Ms. Fiesel, regarding the WRI Fiesel cross-examination Exhibit 1, which was the printout from Paychex Flex regarding the May 9th salary of Ms. Lockwood. The annual amount was given. How many hours is that?
That is 15 hours a week.
Okay.
Ms. Fiesel and Ms. Strickland from the public staff went on a field audit to Charlotte to visit WRI, and we were there, and she asked the question on the field audit, how many hours? And then we also followed, she asked another question to Ms. Lockwood, and we sent a response,
On
an
an
email on 4/4/2024 at 3 o'clock in the afternoon, and where she stated that she worked 15 hours a week.
So their payroll, they do basically an annual payroll with with all their employees, and then they break it out into a weekly. And I think, Ms. Fiesel, I think she used 40 weeks even instead of 42 weeks when she did her calculation.
52.
What?
52.
52, sorry. She did 40, yeah, she used 40 weeks instead of the 52 weeks that you should have used anyway. So we were but we do realize that she's taken on 3 new roles, and if you can hear the history, they had bad customer service, and now they hired Beth to do the customer service, and they had a terrible bookkeeper, because we have gaps in the records. I think the public staff was aware of some of the data requests. We did have some gaps because and so she fired the bookkeeper and added duties to Ms. Lockwood to do. And so now she's also the administrative assistant. So she has increased her duties. And I think just with the interconnection, the boss hadn't gotten around to giving her a raise that she needed. And so we put in rebuttal when we filed that by May, by the hearing, he would have that rate in with the payroll company, and he did. So that's where that comes from. We got the confirmation last week, and we sent it to the public staff in an email.
Okay, all right, thank you. Thank you for that clarification on that. Also, talk to me a little bit about the interconnection to the town of Harrisburg from the accounting side, the depreciable life of 20 years. When Mr. Hauser got on the stand, he explained that, the bulk of those assets, the public staff's recommending to depreciate it over 50 years. And his reason and his rationale is, his view, most of the infrastructure is pipe, which has a 50-year life or longer. So when the company presents its recommendation of a 20-year life for actually the entire group of assets, as I understand it, let me hear your rationale of how you got to 20 years.
So, I think we were trying to come up with some kind of composite rate. When I, was looking at the pictures of that asset, I initially probably thought a lot of it was pipe, but it doesn't look like it's all pipe to me. I'm very visual. Looks like there's the meter, there's wiring, there's valves. There's all kinds of equipment there. And just to say that it's just all pipe, I don't think is correct. Mr. Hauser did point yesterday, which I did go look up. He pointed out an exhibit capital NS from the Aqua case in the W-218 sub 526. It's not the NS schedule. It's actually should be the NW schedule. And I did find where he recommended the distribution and transmission mains from Aqua. And the rate that I think he said on the record was 58 years, and they recommended 50 years. But it just seems to me that there should be, you know, some kind of composite rate, not just mains and pipes. I mean, when I look at these water utility accounts, I mean, I'm at a loss for exactly all the things that this piece of equipment involves, that, you know, where it would fit in one category. I think it fits in maybe several categories.
And how did,
The
oh, sorry,
public,
no.
the public staff, you know, they just state in their testimony that it's similar to Aqua and Carolina Water, which he did provide this, you know, but it's really, you know, I can't determine that the whole interconnection project is, you know, applicable to just one line item. They never gave us anything until yesterday to look at. We've looked at depreciable lives over assets of other utility companies, and 25 years seems to be a typical use. We just have worked on companies that, you know, a major portion of a plant just got 25 years. So we thought the 20 was reasonable.
Okay, all right, that's helpful.
And,
Oh, yes.
sorry, but we, you know, when I was a accounting manager, our division did, the engineers didn't look at the depreciation studies as much as the accountants did, which is horrible, honestly. But, you know, you say transmission mains, and I think that Mr. Hauser was right with, there are definitely transmission or distribution, really, because 4 inch to 6 inch is really distribution. And so, but in those categories that you get in these studies, there are different components, and they do break out them all. And at the end of the day, you might have, you know, somewhat of a composite, you know, even in the transmission or distribution area. And so what we were trying to figure out was they put the initial system in that was approved in like a sub 2 case or something, and they used a 25-year composite back then for the initial system. And so I think that's kind of where we were coming from at that point in time. But, you know, we do recognize that even though it might be a distribution type main, there are so many components listed, you know, in the depreciation schedules that we see, that we've seen in our past, that show the electronics or the you know, these compressed, you know, just all the different, there's a backflow, there's a, you know, and I work for a water and sewer company now, so I'm really getting way too much information on a daily basis about water and sewer, because we rehab water and sewer pipes after the, you know, 40 years or 50 years, and they go bad. So we're learning a lot in my old age, but I just think we were just trying to find a happy medium, and maybe 20 wasn't the best one, 25 maybe we should have gone with, but that's kind of where we were at with this.
And I will say in our testimony, we did say that, you know, the most expensive parts of the project were the meter valve, the vault, the electrical, the signaling equipment, and it does have much shorter lives than pipes. So I think if you're considering it all as one component instead of breaking out every little part, that 50 years is a little bit too long.
And how did the company record it on its books? As one lump sum, or did they break it out into like the valves and I mean, did they do any breakdown on their accounting
I
records?
think it's a lump sum. I don't
Okay.
think she broke it out into any individual components.
Okay, all right. And regarding the, that one-time fee, the one-time development fee, as I was going to ask how that was recorded on the books too, and it sounds like it was all one piece. But based on your accounting experience and any review of the USOA, any familiarity with how to record, how the company would properly record a perpetual asset that's not land, that's not an easement, any past experience with that based on your accounting experience that you offered up to the company?
I think we just looked at the development fees as part of an integral cost of the whole entire project. We didn't try to break out individual components of the project. You know, you can't interconnect if you don't pay the development fee. The equipment's no good if you can't interconnect with the town. So we looked at it as part of one complete project. And in my experience with working for the public staff for over 30 years, I mean, we looked at the project as a complete project. And if the project was reasonable and prudent, and it was used and useful in providing service to customers, it was able to be recovered in rates.
And I mean, we've had we worked in electric and gas for years. I mean, they would connect into the FERC pipelines. You know, they'd have connections. They would have gas pipelines connecting to FERC pipelines, and they would have connecting to municipal systems. And I don't ever recall anything being pulled out separately. And once again, the accountants will do a lot of the plant in the gas section of this stuff. And so the development fee and when we asked for support for it, if you don't mind, but when they asked for support for it from staff, quick data request, quick turnarounds, and they provided this aqua case for this capacity fee and said it's related, it's similar to this is why we pulled it out. And that capacity fee was for future customers. And in that order, the commission sort of basically states that they wanted to put a capacity fee in rate base. The commission said no, because it was not used and useful for providing service to customers now. It was for future customers. I'm sure there's a lot more information in there. That's what we got in the response for our rebuttal data request. And so as we were looking through it, we were just going, this is providing service now, and you cannot have one without the other. And I know we're not engineers. We've talked to our friends that are engineers that have retired from this place, and they're like, if it's part of the project cost, it's part of the project cost. And that's how we've always viewed it as far as in all of our plant and service. You make sure it's used and useful by today, and it is, and it's providing service. And they wouldn't have service. And if they didn't have, it's like a permit fee. I mean, you pay the one-time permit fee, and to get your CPC in or to get whatever you need to do to put this project in, and then you keep rolling. You've got to, you pay it, you start building, I don't know. I've never seen where you pull something like that out separately. And that was surprising to us. And the example they gave us did not match, because all the commission said was it wasn't used and useful. So you can pull it out. And in this case it is. So,
But it's an integral part of this project.
yeah, do one without the other. So.
All right, well, thank you.
That's
for
a
that.
key point. It is integral.
Okay, I appreciate that clarification there and that input. All right, I'm gonna switch gears for a minute and ask about the website. How is that going? Is it up and running today as you had hoped?
It's, it's not accessible to the public. We're in the final testing phases. We started earlier this month doing the actual testing, field testing, if you will. And we did find some glitches in it. So those are being worked through now. We still are very hopeful that we're going to be able to roll it out to our customers with this month's billing at the end of the month. But we're very confident if not, because the glitches haven't been fixed or we find new glitches, that the billing at the end of June, that we'll be able to roll that out to our customers.
Okay. I note that public staff witness Hauser had a recommendation about that timeline for I guess completing the website or getting it functional to the customers. And I believe that was a 6-month deadline. And I believe in the rebuttal testimony, you stated that you didn't really believe the public staff should establish a deadline of that nature. Do you want to speak to that? Tell me what your opposition to that is, or do you think it can be done in the 6 months?
We won't have a problem getting it done within that time frame.
Okay.
In fact, I would say we probably, with a 6-month deadline, we'd be under promising and over delivering, which is what we prefer to do.
I think he recommended fines if it wasn't.
Yeah.
And that may be what y'all
He-
objected
I think
to.
that's-
Yeah,
Okay.
he's recommending fines and reporting, which, leads to another issue, professional fees being incurred. I mean, so.
Okay, all right. Thank you for that clarification on that. So, but I do hear you say that the website itself will be up and running for customers within 6 months or sooner, actually. Okay, all right. And speaking of recommendations from the public staff, just to, if you could, maybe address just verbally for just a few minutes. This is on page 16, starting on page 16 of Witness Hauser's, supplemental testimony. I believe it's a supplemental. Let me make sure. It's the testimony that was filed on April the 15th. Is that the supplemental? That's the original. I'm sorry. That's the.
Oh.
It's the original that was filed on April the 15th, and it's, or the chief clerk stamped it the 15th. It was probably filed on the 12th, the day it's dated. And I'm on page 16,
Okay.
and this starts, let me see if yeah, on 16, hang on just a second. Oh, I'm sorry, I'm on page 17. The top of page 17, a question and answer starts that says, what recommendations do you have to address the issues regarding the Rocky River system raised at the customer hearing? And Mr. Hauser lists several there, and I was including a recommendation regarding the website. And I wondered if you had a chance to review that and if there was any opposition to these recommendations by the public staff.
Yeah, regarding the effectiveness of the filter, depends on what he considers evaluation. We are taking weekly samples of the water supply after filtration to make sure the filter is still being effective in removing iron and manganese. So if that's his definition of what evaluation is, then we're fine doing that. That will be an ongoing thing that we're doing now.
Okay.
Investigate the need for interior cleaning of the elevated storage tank. I believe we're due for an inspection this year on the storage tank, and that will be part of the inspection, so we're happy to do that.
Okay.
In regards to public staff data requests, that it never replaced the media in its filter. We had previously given updates to the public staff about that and explained to them that we field test had shown that it wasn't necessary. And why would asking to explain why we would have that, they would want us to have that expense when it wasn't necessary. We never got an objection from public staff that we had not replaced the media. They didn't comment on our field test and the fact that it showed that it was being effective. So that's why we haven't moved forward with that expense. Continuing on to page 18 about the line 1 there, opt-in customer email communication to regularly send announcements. Part of our website rollout, they will have to register, and part of that registration will include capturing their email address.
Mhm. And then there's one more.
We got a little bit of feedback, don't we?
Okay, and the deadline to implement the website was, and that was, so I think that was the one you just said. So, yes, okay, yeah, okay. It should be operational by June.
And you're speaking to which one now?
The last one you had, what you already asked about was sort of the deadline on the website.
Mm-hmm,
And I
yes,
think it should be done by June,
okay,
no later than June anyway, so.
Line 15 of page 18.
okay. All right, yes, that we just spoke about, yes. And then I think the last one's the top of page 19, that the company continue its 3-month reporting of customer contacts. What's the company's?
We're
position
fine
on that?
doing that.
Okay, all right.
But we need professional fees to do it.
That's right.
Noted. All right. Okay, so thank you for going through those one by one. Okay. Um, cover it all. I think we're done. Okay. Okay, I think that's all of my questions, so I'm gonna allow public staff.
I believe, Ms. Peden, you stated that, you used, a composite rate to determine the life of the interconnection pipe. Did you break it down into different components at all?
No. I looked at, other cases, where the service lives have been approved by this commission. It just seemed to me that it would represent some kind of composite rate. I didn't do a calculation.
Okay. Did you consider choosing the 20-year life, based on how quickly the company would get recovery?
No. I think that we looked, like I said, at other cases. Some of the cases that we looked at had 25 years. We did recommend 20. We've also know that sometimes general plan is 30 years, but we didn't think it would be 50. 50 is just way too long.
Now, you contend that the development fee and the actual interconnection pipe should be considered one project, correct?
Yes.
Yeah,
Okay. Now, isn't it true, however, that the development, they were paid for separately? The development fee was paid to the town of Harrisburg, correct?
Every cost of the project was paid separately.
different contract.
KIP Corporation was the contractor for the case. He was paid separate and may have been paid in several invoices. And
Right.
what we tried to do was just include every line item on how they were paid by the company.
Paid engineers, we paid surveyors, we paid electrical
Electrical.
contractors that were separate from the other contractor. We paid the town of Harrisburg. We paid a contractor to do boring underneath the road. So we paid we paid a lot of people, a lot of people.
Right.
And we separated it out so that it would be easy for us to provide the invoices to you to support what we were requesting.
But the bulk of the cost was paid to the contractor, KIP Corporation. The bulk of the cost.
Yes, I
for the
would say.
actual interconnection project.
I know it was,
He's the contractor.
I know it was upward of $230,000-ish.
232,150. Would that be
That
correct?
sounds
Okay.
correct.
All right. Subject to check.
But once again, you would not be able to use any of that was built if you didn't pay the development, you didn't connect to the town of Harrisburg. And this is the only reason why this is the only reason why, does he think he really wants to pay $99,000 or whatever for the 101? They pulled the meter out. But who wants to pay $101,000 to another entity? And I mean, that would not be my first choice, but you have to. In order to get service and to provide service to customers as required, you have to, and it's just part of the project cost.
But but generally aren't, different components of a project given different, separate depreciation lines?
You gave us none. We have no depreciation on this one, so.
On,
That's on the development fee.
no. Correct.
Which we concede is part of the entire project. I mean, you can't just say this part of the project was not integral, so we're not giving you depreciation. You have to give depreciation on the whole entire project. I don't recall that you don't get depreciation on the entire project. I mean, I haven't even seen an example from the public staff that has indicated that in this case at all. There's no citations at all for not including it.
Well, and
I mean-
Evan broke out the meter, and so because Mr. Hauser, I'm sorry, let me use the correct names. There, then public staff engineer, Hauser, pulled out the meter. That was not us pulling it out. That was the public staff pulling it out. And they put a 15-year life on it, you know, and we think there's other components in there that in the composite that we're trying to look at that may have different lives. But the development fee is part of the project, and it is, I mean, you can't do one without the other. It is completely, I mean, it's the reason for the project. I mean, this is the reason for the project.
Is land appreciated?
Land is not
No.
appreciated.
But that could also be part of a project as well, correct?
True. I don't
That
think
is
we have any
true.
in here though. I think, and we also don't have any AFUDC. We also didn't prove AFUDC on anything. There's no financing charges, which we could have done had you contacted us a couple of years ago. I mean, so there's no financing cost in this, any of this money.
But we don't separate that out as part of the project
Right.
either. It's just incorporated as,
You would have just
part of the
incorporated that
project.
as part of the main project. So, I mean,
All right.
enough said, but yes.
No further questions. Thank you. Enjoy your lunch.
Just a few. Mr. Abbott, we passed out at the beginning of the examination on the above these pictures. And if we flip through those pictures to show the interconnection, somebody can look at those and see some of the components that we're talking about here on this project and determining depreciation expense, can we not?
Yes, sir.
And you've got pipes and some pipes, you've got valves, you've got meters, you've got wires, you've got stuff that up. Got aerials and all sorts of things.
Electronic equipment.
Yeah, electronic equipment. So that helps illustrate the point we're discussing.
Yes, sir.
No further questions.
Okay, thank you, Mr. Finley. I think that concludes the company's case. So thank you, witnesses. You may be excused. We thank you for your testimony today and yesterday, Mr. Abbott.
Thank you.
And with that, we'll talk about how to bring this case to a conclusion. And one thing we'd like to mention is there are some late filed exhibits that are going to be filed. And Mr. Finley, you'll have an opportunity to look at those late filed exhibits. I think they're all from the public staff, if I recall correctly. I would also like to request proposed orders to be filed. And I would wonder if that could be done, or what time frame y'all would like. Let me ask that, because I know everybody's got a certainly busy schedule. Are you thinking 30 days after the transcript, or something longer than that?
30 days is what we prefer.
All right, 30 days after the receipt of the transcript, which may be early next week, maybe Monday. Okay. And then let's talk about Mr. Finley, the date that the company expects to file their supplemental report. How many days do you need for that? This was the response on the, and I'm speaking to the report on customer concerns.
I hope, Madam Chair, that I'm going to leave the country today about 4 o'clock in the morning to go to Bolivia for 10 days. Mission trip. I'm going to try to help people be fitted with glasses. Someone needs to fit me with glasses. But 20 days.
Yeah, and the public staff will get 2 days to respond, 2 business days. So, okay, All right, okay, that will be allowed. And then I want to ask, when the parties file their proposed orders, the commission staff would like the Excel schedules that we get, customarily get that, support your calculations of, the revenue requirement and rates that each of the parties will be proposing in their file, in their proposed orders. And I would ask, if it's not burdensome, if the parties have Excel schedules that are ready at this point in time, and that would be the public staff, Lynn Fiesel, and the consulting firm, Darden and Peden. If we could, if commission staff could have what is ready, and it may be your final position, but if it's not, you can still file it updated with the proposed orders. But commission staff would just like to go ahead and start getting familiar during this 30-day period we have between now and when you file your proposed orders of how your schedules are working. So that would be helpful if you could just email those to Jenny Lee.
Okay.
All right, thank you. Is there anything else from the parties? I know Ms. Holt, you objected to the summary, so you can follow up on that. Is there anything else that was pending before we bring this matter to a close? All right, well,
I need to move the admission of, if I haven't already, public staff, WRI panel cross exhibit, WRI rebuttal cross exhibit 1 into evidence.
okay, and without objection, that will be allowed. And I'm glad you said that, Ms. Holt, because you reminded me. I would also like the parties, if there's no objection, I would like to enter into evidence the report on customer concerns that it's a report of Dennis Abbott for Water Resources, Inc. on customer testimony that was filed on April the 8th in the docket, and then the public staff's verified response to the verified report on customer comments from the public staff by Water Resources, Inc. that was filed on April 22nd. So that will be so entered. So there's been no objection to that. And I think we'll have all of the evidence. And your affidavit of your public staff witness from the economic research was accepted into testimony by order. But just in an abundance of caution, the affidavit of Gregory Rieger is entered into the record as well, as if given orally from the stand.
Okay.
So we'll have everybody in the evidence.
I guess I would move that these pictures for illustrative purposes only be made a part of the record.
Yes, and without objection, that is allowed. And with that, I thank everyone for their testimony and for coming out for the yesterday and today. And thank you for being good witnesses and good attorneys. So thank you. And we're off the record.